Judge, it's not my responsibility to walk witnesses in for the prosecution. If he was subpoenaed,
that's why your witness is in jail.
I understand that, Judge. But so as far as today, it sounds like the hearing is not moving forward. So I guess I'm wondering what the court is wishing to do from here. We're asking for the detainer to be set aside. Obviously, he has counsel. Obviously, he's here today, and will comply with any subpoena he's served.
I'm not confident in that.
You need a marker, Judge? There's a witness.
You want to waive your client's presence? No?
I can't, Judge. Not this guy. He's
Okay.
this is a weird case.
You need the witness to be go right now?
Not yet.
Not yet today. You'll need today.
We'll need him today. That is, I'm gonna have to investigate this container.
Yes, Judge.
Maybe we'll do that now.
Okay.
Let's deal with the container.
You want to amend the witness chair?
No.
Second. Go to the podium.
Okay, this is in the matter of William Weems Jr. File number 23059386601. Appearances for the record, please.
Good morning, Your Honor. Anna Bicker, staff on behalf of the people, P82215.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Natalie Phelps, P83355. Appearing on behalf of Mr. William Weems, who's present in the courtroom. Mr. Weems, can you please state your name for the record?
So Mr. Weems is before the court when he witness detained.
And Judge, for the I haven't seen the demeanor. I don't know if I could take a look at that before we proceed further this morning.
It's just basic boilerplate detainment. It doesn't really set forth any facts. But you're free to look at it.
Thank you, Judge. May I approach?
Sure. So why did the people request a witness detainment from Mr. Williams?
Yes, Judge, based on the information that I actually spoke to Mr. Williams myself and from the officer, was the people's understanding that he was evading service. The officer in charge did speak with Mr. Williams, who told him he wasn't coming no matter what, he's not going to testify. And then after that, when the officer tried to contact again, he had shut down his phone. So I reached out to the probation agent to see if she had an updated phone number. At that point, somehow the probation agent actually gave Mr. Weems my cell phone number, and Mr. Weems reached out to me and said that he's not coming, he's not going to testify no matter what, he doesn't want to be involved, he's not coming.
And Judge, Mr. Weems was never subpoenaed in this case, is my understanding. There was.
How can they subpoena these evading service?
Well, I didn't hear any facts about the evading service, Judge. I don't think he's actually doing that. Nobody tried to pursue the service with the subpoena.
But we'll take, somebody tells you what they're going to do, somebody tells you who they are,
Well,
then you believe.
Judge,
He's not coming and he's not testifying.
Judge, it's my understanding that during his conversation with Ms. Bickerstaff, he also did indicate that he was represented by counsel and he would speak with his counsel, which was me. And after that is when this witness detainer was sought, and it was done ex parte, even though Ms. Bickerstaff knew that he was represented by counsel. And that's where the issue happens, Judge, is that he let her know he could speak to his counsel, and then after that, they still issued the detainer. So obviously, if he's seeking counsel, you know, if he was given a subpoena, then he would have had the opportunity to comply with the subpoena, and he never was given that opportunity.
And Judge, if I could just add what Ms. Phelps somehow left out, it was that after Mr. Williams told me that, she was my next call, and I did speak with her, and I told her, here's what your client said, try to talk to him, tell him what's going on, tell him what's going to happen if he doesn't come, and then let me know. And I never heard back from Ms. Phelps, and that's when the people saw the detainment. I did give Ms. Phelps and Mr. Weems the benefit of the doubt, hoping she walked in, and I never heard back.
Judge, it's not my responsibility to walk witnesses in for the prosecution. If he was subpoenaed,
That's why your witness is in jail. Right? He was trying to
all
get in
right,
jail
I
right
understand that, Judge, but so as far as today, it sounds like the hearing is not moving forward. So I guess I'm wondering what the court is wishing to do from here. We're asking for the detainer to be set aside. Obviously, he has counsel. Obviously, he's here today, and will comply with any subpoena he's served.
now. I'm not confident in that at all.
But Judge, again, nothing has been put on the record about him being personally served. He's had counsel advise him about a subpoena, and he hasn't been
And
subpoenaed.
yet,
If he's handed a subpoena right
and
now,
yet counsel didn't even secure his presence. Right?
you're saying it's my responsibility to secure somebody who's not been subpoenaed?
Okay, so let's follow your logic, man. I let him out, and he doesn't show up. You're gonna come here and say, is it my responsibility to have him show up?
Yeah, that's right.
Okay, so no, I'm not gonna rely on you to get him here. I'm gonna take him for his word that he's not gonna show up.
One
And
moment,
he'll
Judge.
stay here until the preliminary examination.
And Judge, again, the word that he gave to Ms. Bickerstaff was before he consulted with counsel on complying with the subpoena. And he has not been issued a subpoena, and he will comply with the subpoena.
I don't think so.
Can we state on the record, Judge, what makes you believe that? And maybe he's
Taking
have an
him at his
opportunity to
word.
tell you that he will. Now that he's had an opportunity to consult with counsel. Judge, could I have a moment with Mr. Reeves?
Okay. Are you ready?
Mr. Weems would just like to clarify that the reasons why you were saying that he wasn't gonna come and testify. When he was interviewed by the police, they did a video recording of him, and it was his understanding that he would have to come into court and testify. It was actually what the officer told him, at least his understanding of what the officer had told him, and so that's why he was saying he wasn't gonna come to court until his duty in this case was done, but he absolutely will comply with the subpoena and be here on November the 30th for the next hearing.
So let me hear it from you. Why did you indicate to the prosecutor that you weren't going to show up?
Because I had a different case going on. And long story short, they approached me before I talked to them.
Can you step to the podium so I can hear you from the microphone?
Here,
Yes, sir.
I had a different case going on. For that case, they approached me verbal. And I made a video from a play of in this case for that. And he basically told me that if I did this one, the gun that he took, and I wouldn't, basically he'd give my gun back, and I wouldn't have to do an in-person court form. This case, like I basically done this case. Yeah. So
Weren't you made aware that you were supposed to be here to testify? That they wanted you to come in and testify?
After the fact, yes. But I made a video because he said I wouldn't have to testify in person.
But you understand that you do have to testify, right?
I did not, yes.
Judge, I'm just indicating, when I spoke to Mr. Williams on the phone, he did say the same thing about, he thought there was a video, so he doesn't have to come, and I told him that's not the case. He does have to come, and then he again reiterated, he doesn't care, he doesn't want to be involved, he's not going to testify. So I'm just indicating that I did try to clarify that point for Mr. Williams when we spoke.
Is that right, Mr. Williams? She's lying?
Yes.
I don't believe you.
Don't words in my words.
I'm sorry.
Don't words in my words.
Who were your words?
My words was, I asked her if I got something. She said no. I told her my lawyer's name. The same thing I did with the detective.
So I am going to err on the side of caution, and I am going to hold Mr. Williams until he testifies at the preliminary examination.
Can I?
Sorry. Okay, thank you.
It's nothing I can do. I
Hey, man, just, it's okay. It's all right. I know. Judge, we're asking you to reconsider that. Again, Mr. Weeds has indicated he will be here on November 30th. He will be here represented by counsel. And so we're asking for you to release him from the detainer, Judge.
No, I'm not. Thank you.
Yeah, okay. I know that, like, there's nothing I can do. Like, I'm telling you, I'm really doing it.
I don't believe you.
Sorry. That's what.
I don't believe this. Right?
Judge, will the tether satisfy you?
No.
Come on. Can I ask you one question, sir?
You're all set. Now about your turn.
Jesus Christ.
Great.
Can I have a copy of the detainer, please, Judge?
I thought I gave it to you. I thought I gave it to you.
I give it back to you, Judge.
I gave it back to you.
Oh, yes.
Yes, I'm gonna go down and do it right. After here.
Calling case 2359886, people of the state of Michigan versus Brandon Jordan Crane. Petitioner is charged in count 1 homicide, murder, first degree premeditated. Count 2 felony firearm, count 3 carrying concealed weapon. Appearances for the record.
Good morning, Your Honor. Anna Biggerstaff on behalf of people, P82215.
Good morning, Judge. Patrick Nineheist, P76343. On behalf of Mr. Crane, is present. Say your name, sir.
Great. There's a date time set for preliminary examination. We had some sidebar discussions and that I understand there's some outstanding discovery issues. Is that right?
That's correct.
That's correct, Judge.
Okay. And given the outstanding discovery issues and the defense attorney needs to be prepared to defend his client, the court finds good cause for an adjournment. I believe you have an agreed upon date of, what is it?
November 30th.
November 30th at 10 o'clock?
That's correct, Judge. Thank you very much.
November 30th at 10 o'clock. You wanted to address mine?
Yes, Judge, we asked for a DSU report, a pretrial services report,
We have one.
and I wanted to explain a little bit about Mr. Crane. He takes care of his 9 nieces and nephews, plus he has 3 kids, is that correct, Mr. Crane? And he has this case is from 2020, July 5th, 2020. He's still in the city of Detroit, still has strong family support. We're asking for a GPS tether with house arrest so he can take care of his nieces and nephews and his children. He currently also has, I got contacted by Joey Dominic, who works for the Youth Build, the Youth Build coach, and this program allows participants to get a stipend and start working and learning a trade as soon as possible. So he would be making between $400 to $800 a week. And he'd be learning a trade, so he'd have a trade due after he completes that course. He'd be certified as an electrician or a plumber or whatever he decides to go into. The program started last week, but they kept it open for him until Mr. Dominic, D-O-M-I-N-I-C-K, said that it was going to be open for 14 days. Mr. Crane successfully completed the Homes Youthful Training Act from, I would say, the same incident, basically. He was arrested on July 5th with a firearm. And that firearm, he pled guilty to having a concealed weapon on him, successfully completed probation from Judge Wanda Evans of the Third Circuit Court. He's not a flight risk. And
Are you sure about that?
I am sure about that. Judge has been here the whole time since he got arrested on July 5th.
Of course he has, he's in custody.
July 5th, 2020, Judge, he successfully completed
He has an
probation.
extensive failure to appear. Did you know that?
No, I haven't had a chance to look at that report.
He has a very extensive failure to appear. He has an attendance charge. So they recommend no action. He's charged with first degree murder, premeditated. He has an extensive failure to appear history. For that reason, protection of the community, and so that does not pose a flight risk. The court is going to remand. Thank you.
Thank you, Judge.
Search that as well.
Judge, can I request that transfer from the last case for Mr. Williams? Okay, thank you.
Still record.
Good morning, Mr. Williams. So we're waiting around on your attorney, but we have an option for you. You can choose to represent yourself and ask for a dismissal, or you can wait on your attorney. Which one is it?
Oh, that's fine. That's fine.
What's fine?
I'll do it myself.
Okay. Brian Williams, calling case 2359021. People of the state of Michigan versus Brian Ramon Don Diego Williams. Defendant charged with count 1, assault with a dangerous weapon. Count 2, felony firearm. Count 3, domestic violence. Appearances for the record, please.
Good morning, Your Honor. Gabriel Floyd, requesting permission to practice under court law 8.210 under the supervision of the agent.
Commissioner Grant, tell me your name, sir.
Brian Williams.
Today's the date and time set for preliminary examination. Are we ready to proceed?
Your Honor, the complainant witness in this case is not present as people are unable to pursue documents.
Sir, you have a motion for him?
You said,
You have a motion for him? Motion to dismiss?
yeah,
Here you say it.
that's why I have a motion to dismiss.
So, or the court will dismiss this matter without prejudice.
Thank you.
All right, thank you.